Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. We are experimenting with the StreamYard. You can see it, the little logo right there. I've never used it before, so this is my first time experimenting with it. If it works, we may pay for it and eliminate the logo. If it doesn't, well, we'll go back to shooting on some other way. So I had promised I was going to address the Second Amendment Preservation Act. That act, I believe, has problems. I love the idea that Missouri's legislature wants to do something to strengthen our Second Amendment rights. I'm just not sure that that's the correct process. But let's go through what the Second Amendment Preservation Act looks like and is. So I have the text of it right here. So starting with the new section 1.410, this is the Second Amendment Preservation Act. Paragraph 2 on line 3 starts with the General Assembly finds and declares that the state is firmly resolved to support and defend the Constitution of the United States against every aggression, whether foreign or domestic, and is duty-bound to oppose every infraction of those principles that constitute the basis of the Union of the States, because only a faithful observance of those principles can secure the Union's existence and the public happiness. Okay, I'm going to pause here for a second and point out that Missouri had some issues during the Civil War, and hearkening back to those days may not be the best way to start this. So let's go on. Acting through the Constitution of the United States, the people of the several states, you know what? I'm going to tell you, you can find this at house.mo.gov/bill tracking/bills. Okay, you can Google it. You can find this. It's not going to be a problem. We're going to skip through. This is 9 paragraphs and a page and a half of feel-good nonsense that says next to nothing. So now creates section 1.420. You would think they'd reserve that for marijuana. But section 1.420 reads as follows. 1.420. The following federal acts, laws, executive orders, administrative orders, court orders, rules, and regulations shall be considered infringements upon the people's right to keep and bear arms as guaranteed by Amendment 2 of the Constitution of the United States and Article 1, Section 23 of the Constitution of Missouri, within the borders of this state, including but not limited to. Now, before I get into the subparagraphs where it says including but not limited to, part of the basic fundamental problem I have with this act is this section right here. Okay. That 1.420, the following federal acts, laws, executive orders, administrative orders, court orders, rules, and regulations shall be considered infringements. Okay. You would think that after opening like that, the following federal acts, you would list a federal act, law, executive order, administrative order, court order, rule, or regulation that is an infringement, or this declares shall be considered an infringement. But we don't do that. Instead, we drop to paragraph 1 here. Any tax, levy, fee, or stamp imposed on firearms, firearm accessories, or ammunition not common to all other goods and services, and that might reasonably be expected to create a chilling effect on the purchase or ownership of those items by law-abiding citizens. Well, that is not a federal act, law, executive order, administrative, court order, rule, or regulation that this statute says follows it. So while this is feel good, it has no meaning. Paragraph 2. Any registering or tracking of firearms, firearm accessories, or ammunition that might reasonably be expected to create a chilling effect on the purchase or ownership of those items by law-abiding citizen. Again, this is not the following federal acts, laws, executive orders, administrative orders, court orders, rules, or regulations. This is a feel-good idea. This is what we don't want. This is what we'll consider infringements. But this is not the following federal acts, including but not limited to. These are subjects, not the actual laws or acts that are considered infringements. So this is poorly written right here. And paragraph 3, any registering or tracking of owners of firearms, firearm accessories, or ammunition that might reasonably be expected to create a chilling effect on purchase or ownership of those items by law-abiding citizens. Okay, as we run through all of those, paragraph 4 is any act forbidding the possession, ownership, or use or transfer of a firearm, firearm accessory, or ammunition by law-abiding citizens. 4 is actually the closest to being valid. And 5, any act ordering confiscation of firearms, firearm accessories, or ammunition from law-abiding citizens. So 1.420 is next to meaningless, and it's feel good. Basically, it's theater, but that's what you get in politics. Politics is all about theater. 1.430, all federal acts, laws, executive orders, administrative orders, court orders, rules, and regulations, whether enacted before or after provisions of section 1.410 to 1.485 that infringe on the people's right to keep and bear arms guaranteed by Amendment 2 of the Constitution of the United States and Article 1, Section 23 of the Constitution of Missouri shall be invalid in this state, shall not be recognized by this state, shall be specifically rejected by this state, and shall be considered null, void, and of no effect. That actually has some meaning. It's ridiculous and unconstitutional, but it has meaning. Okay, all federal acts, whether enacted before or after. Okay, this is all federal acts. In 1.420, it says the following, and then fails to list them. So 1.430, all federal acts, all laws, all executive orders, all administrative orders, all court orders, all rules and regulations. Although here's a tip. If you're telling the court that its court order is invalid, not recognized, null and void, your recourse is probably not going to be in that court. So while that may have some impact, the issue that you have with it is they're arguing that the Second Amendment of the Constitution and Article 1, Section 23, that any federal law has to comply with our state constitution for it to be valid in the state of Missouri. This is the same state constitution that the Missouri State Supreme Court essentially declared null and void after this amendment was passed, and the court considered it and said, you know what? We really don't care. So, and the Second Amendment of the Constitution of the United States, the federal bench has held that there are reasonable restrictions on the Second Amendment. While I may disagree with that, that is the current holding, that there can be some reasonable restrictions. So while this 1.430 has, again, it sounds good, it is essentially meaningless because, one, you're not going to have the recourse. Second, it's simply not constitutional. You're going to declare a federal law void in the state of Missouri. Okay, we'll come back to that. So yeah, we'll circle back, right? 1.440. It shall be the duty of the courts and law enforcement agencies of this state to protect the rights of law-abiding citizens, to keep and bear arms within the borders of this state, and to protect these rights from infringements defined under section 1.420. Well, 1.420 didn't define infringements. 1.420, as I scroll back to it, maybe, 1.420 said the following federal acts shall be considered infringements, and then didn't list any federal acts. It did list some ideas, but that's not defining the term infringements. So again, here you have another legal writing problem, that infringement is not defined. Might there be an implication? Maybe. Could you reach an inference? Maybe. But if I was on the other side, I could drive a truck through this. Well, 1.450, no person, including any public officer or employee of this state, nor any political subdivision of this state, shall have the authority to enforce or attempt to enforce any federal acts, laws, executive orders, administrative orders, court orders, rules, regulations, statutes, or ordinances infringing upon the right to keep and bear arms as described under section 1.410. Now, setting aside the grammar and structural issues of this, if no person has the right to enforce those or to attempt to enforce them, if they're an employee, officer, or a political subdivision, that, okay, what's that going to get you, man? I don't know. 1.460, paragraph 1, any entity or person who acts knowingly as defined under section, you know what, before I go any farther, let's scroll back. Let's take a look at this Article 1, Section 23 of the Constitution, because it's referred to a few times, and we need to know exactly what that is. Okay? Article 1, Section 23. The right to keep and bear arms, ammunition, and certain accessories. Exception, rights to be unalienable. That the right of every citizen to keep and bear arms, ammunition, and accessories typical to the normal function of such arms in defense of his home, person, family, and property, or when lawfully summoned to the aid of civil power, shall not be questioned. The rights guaranteed by this section shall be unalienable. Any restriction on these rights shall be subject to strict scrutiny, and the state of Missouri shall be obligated to uphold these rights and shall under no circumstances decline to protect against their infringement. Nothing in this section shall be construed to prevent the General Assembly from enacting general laws which limit the rights of convicted violent felons or those adjudicated by a court to be a danger to self or others as a result of mental disorder or mental infirmity. Now, I'm going to remind you all that after this was passed, there were several court cases, and it was the felon in possession cases, where somebody who was convicted of a nonviolent felony was arguing that they, under this constitutional amendment, they had a right to their firearms back. Now, they were being charged criminally, so this went up on the criminal side. The Supreme Court held that it always applies strict scrutiny. Strict scrutiny applied to the felon in possession statute, and therefore there was nothing wrong with it, even though a maximum of law is the inclusion of one is the exclusion of others. So by saying enacting general laws that limit the rights of convicted felons, they're saying that you can't enact a general law that will limit the rights of convicted nonviolent felons. But the court didn't see it that way, and the court basically nullified this as it applies to any felon. That is a very brief summary, and it's a very biased summary. If you want, please go look it up. David Rowland at the Freedom Center of Missouri was the attorney that ran with the cases. He did a phenomenal job, and Judge Tiedelman's dissent is the best writing on the subject from the court. And yes, Judge Tiedelman's dissent is what you should look at. The ruling was horrendous. So that's section 23. And I get that. But now when we come back to, there we are. And we come back to this, and they're saying that an entity or person who acts knowingly under RISMO 56016, we'll go ahead and pull that up because I'm playing with this and I can. Under what? Oh, they said 562, didn't they? I know they meant that. They had to mean that. So, knowingly, a person acts knowingly or with knowledge, one, with respect to his or her conduct or to attendant circumstances when he or she is aware of the nature of his or her conduct or that those circumstances exist, or with respect to a result of his or her conduct when he or she is aware that his or her conduct is practically certain to cause that result. Okay? Now, bear in mind, this is directed at your law enforcement officers. So, any entity or person who acts knowingly as defined by 562.016 to violate the provisions of section 1.450 or otherwise knowingly deprives a citizen of Missouri of the rights or privileges ensured by Amendment 2 of the Constitution of the United States or Article 1, Section 23 of the Constitution of Missouri, while acting under the color of any state or federal law, shall be liable to the injured party in an action at law, suit in equity, or other proceeding for redress. In such actions, the court may award the prevailing party, other than the state of Missouri or any political subdivision of the state, reasonable attorney's fees and costs. Sovereign, official, or qualified immunity shall not be an affirmative defense in such actions. That means if this 1.450 is violated, then the officer may well be liable and cannot rest upon qualified immunity, sovereign immunity, or official immunity, which means the officer, the political subdivision, the state, or elected official are hanging on it. Now, (1.470) paragraph 1. Any person acting as an official, agent, employee, or deputy of the government in the United States, or otherwise acting under the color of federal law within the borders of this state, who knowingly, as defined by 562.016, enforces or attempts to enforce any of the infringements identified in section 1.420. Now, see, this says identified, not defined. Okay? This may actually apply. However, because there are listed off things that they considered to be infringements. When we scroll back up to 1.420 and we look at that, it's listing off these things saying, you know, including but not limited to, and then it lists off a bunch of issues. However, not actually the federal acts or laws. So I think that's going to be critically broken because of that. However, they might try to follow this in our state. I don't know. But I think it's critically flawed because there were no infringements identified or defined in section 1.420. There were the following federal acts, and then there were no acts listed. 2, gives material aid or support to the efforts of others who enforce or attempt to enforce any of the infringements identified in section 1.420. Well, again, section 1.420 doesn't identify infringements. Section 1.420, and I'll scroll back up to that because I can, Section 1.420 is telling us that the following federal acts, laws, executive orders, administrative orders, court orders, rules, and regulations shall be considered infringements. The following shall. Okay? Not the following issues, but the following acts, laws, executive orders, administrative orders, court orders, rules, and regulations. Then it proceeds to list absolutely no federal acts, laws, executive orders, administrative orders, court orders, rules, or regulations. This is written pretty crappily. Okay, so any person who gives material aid or support, blah, 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 shall be permanently ineligible to serve as a law enforcement officer or to supervise law enforcement officers for the state or in any political subdivision of the state. Okay, pausing right there. What this is saying is, if you, as a law enforcement officer in the state of Missouri, assist a federal agent in enforcing a gun law that may or may not violate the Second Amendment or Article 1, Section 23, then you're liable. Your good faith as a police officer is no longer valid. You have to know what every court decision is and what the makeup of the courts are, because you have to predict what they're going to say afterwards. Okay, it is ridiculous. It is flawed. However, the upside is you can't really be held responsible for it because they never listed the following federal acts. So that is a real problem. Now we come to paragraph 2. Neither state nor any political subdivision of state shall employ as law enforcement officer or supervisor of law enforcement officers any person who is ineligible to serve in such capacity under this section. Okay, well, we're going to put that right on to the politicians that have even less knowledge. So your local municipal city councilors or city manager that are hiring police, they're supposed to know this without ever having any concept. Any person residing in or conducting business in a jurisdiction who believes that a law enforcement officer or supervisor of law enforcement officers of such jurisdiction has taken action that would render that officer or supervisor ineligible under this section to serve in such capacity shall have a standing to pursue an action for declaratory judgment in the circuit court of the county in which the action allegedly occurred, or in the circuit court of Cole County with respect to the employment eligibility of the law enforcement officer or the supervisor of law enforcement officers under this section. So you can file suit in that county or in Cole County. Now you're seeking declaratory judgment. It doesn't really tell you a whole lot, but when we come over, where's my mouse? There it is. And we come back all the way up here. And we go back to 420. Okay. All of this is predisposed upon the idea that you have to know what that federal officer is intending to enforce, whether or not that is a violation of the Second Amendment or a violation of Amendment 1, Article 23. And you have to be willing to wager that. And again, you don't know because 1, infringements are not defined. 2, this is all just very, very poorly done. You know, they could do this much better by simply saying, 1, the state of Missouri fails to recognize any federal law regarding firearms, period. That would be one way to do it. It wouldn't fly. It would be unconstitutional as hell, kind of like most of this. But you could do that, and you could make your statement of affirmation and get your kudos and collect your thumbs up from the various gun groups by voting for it before you spend a couple $1 million of state money to fight for this or to pretend to fight for this, as the case may be, before losing, having it smacked down, and then walking around saying, oh, I tried. So then if the court determines that a law enforcement officer or supervisor of law enforcement officers, and you can't see this while I'm talking, or supervisor of law enforcement officers has taken any action that would render him or her ineligible to serve in that capacity under this section, the law enforcement officer or supervisor of law enforcement officer shall immediately be terminated from his or her position. The jurisdiction that employed the ineligible law enforcement officer shall be required to pay court costs and attorney's fees. Nothing in this section shall preclude a person's right to appeal or remediation as provided under Chapter 590. So if for sections it defines law-abiding citizen, then we have 1.485. If any provision of sections 4.10 to, or excuse me, 1.410 to 1.485, or the application thereof to any person or circumstances held invalid, such determination shall not affect the provision or applications of sections 1.410 to 1.485, which may be given effect without the invalid provision or application, and the provisions of sections 1.410 and 1.485 are severable. The problem with that, besides being kind of humorous, is they're not severable. It's a nice theory, but when you come in, 1.410 is a generalized statement of belief. It has no meaning in the real world. 1.420 is flawed in the way that I said. 1.430, this one could contain something usable. All federal acts, it doesn't list which ones. This is all of them. If it infringes upon the people's right to keep and bear arms is guaranteed by Amendment 2 of the Constitution of the United States and Article 1, Section 23 of the Constitution of Missouri, it's invalid in the state. Okay? Shall not be recognized, shall be specifically rejected, shall be considered null, void, and of no effect. Well, now we're back looking at the duties, 1.440. Right there, we are discussing whether or not that is severable from 1.420. I don't believe so. Okay. Now, in 1.450, now this is saying that, no person, ordinances infringing upon, no person can enforce. We talked about that. Ordinances infringing on the right to keep and bear arms is described in section 1.410. Well, 1.410 is that great big long diatribe about the people's rights and several states, and supremacy doesn't extend to this, and we don't believe that the Commerce Clause gives the government the right to eat the Constitution, which I happen to agree with. The Commerce Clause is absolutely horrible. It's the exception that's eating the Constitution, and it's completely inappropriate. But what 1.410 doesn't do is anything related to what the claim in 1.450 is. Okay? Because in 1.410, they are not laying out what federal acts, laws, executive orders, administrative orders, court orders, rules, regulations, statutes, or ordinances that infringe upon the right to keep and bear arms are. They don't describe them there. So again, 1.450 is flawed. So 1.460, again, that's the one that says, any person who acts knowingly to violate the provisions of 1.450, which is flawed because 1.410 doesn't describe those. So all three of those are flawed, wasted space. Then you've got 1.470, which refers to 1.470, which refers to 1.420, Again, it doesn't do what it says it's supposed to do. Yeah, I have a real problem with this. So we're going to close that out. And here, the bottom line is that, like anything, the right to keep and bear arms is hotly contested as far as what that means. Some people will say reasonable restrictions. Some people say that doesn't apply to weapons of war. I actually will argue and point out that early court decisions implied that it only applied to weapons of war. So you didn't necessarily have a right to have the snub-nosed 38, but you had a right to an M60 machine gun. So that it's kind of interesting how that has transitioned over the past 150 years. But the Second Amendment is a hotly contested area. There's a lot of law, good and bad, on that. And it's something that people care a lot about, and they need to. It's the defense of our nation. We are not invadable by a foreign power because there is a rifle behind every blade of grass, to steal a quote from Japanese admiral. We are an independent nation for that reason. Now, there's no friendly way to say something should or should not happen. I'm not going to get into the specifics of Heller and all the other court cases, but the pendulum is swinging back more towards individual liberty and protecting rights. And I hope that it keeps going that way, especially in regards to firearms. This is an important issue, and acts like SAPA, which is not going to withstand judicial review, are a problem, because it's going to put all of our law enforcement into a quandary. Can I do this? Can I do that? Am I going to lose my license? And at some point, that's going to lead to a situation where a police officer is going to hesitate. And, we could have police officers hurt or killed. And I know that there's a lot of people that follow me and are on my channel that aren't particularly concerned about police officers. Yet they are between us and the true dangerous people on the planet. So this is not a good thing. That's all I'm going to say about that. I'm not going to get into any additional details, just my impression of SAPA. And the reason that we're doing this is because the reason we covered this, especially this detail, this is one of the things that recently came up with the Supreme Court comment number 8 on Rule 4-1.2 is lawyers are prohibited from advising their clients to take an action that may be legal under Missouri law, assuming this passes, and I think that it will. Legal under Missouri law, but illegal federally. So what happens when you have an ATF agent that's serving a warrant and making an arrest? Well, if they stop in at the county sheriff's office and they park their car and get a cup of coffee, is that rendering material aid? What is material aid? Is it telling them where to go so they don't kick in the wrong door? Is that going and securing the scene so that no innocent bystanders? Is that material aid? We don't know yet. And that's one of the problems. Is the Missouri officer obligated to stop the ATF agent from executing his warrant under this scheme? There may be an argument to that effect. I think that's going too far, but there might be. Of course, I think this whole thing is critically flawed from the get-go. So I think what's largely going to happen is it passes, and then it gets roundly ignored. And when some busybody tries to take their local department to task, it's going to be taken up and then it's going to be eviscerated by the first judge that hears the case. So it's a feel-good measure, but when you look at the comment 8, there are concerns about how you advise. How does a prosecuting attorney advise the police officers in his or her jurisdiction? I don't know. It raises that question. So with that in mind, this was exceptionally long. If you made it this far, you deserve a gold star. Drop a comment that says you made it all the way, and I will figure out how to give you a gold star. Thanks.